Welcome back to Breaking U.S. Immigration News. What I'm about to share with you today is something that's sending shockwaves through the immigrant community across America. Just last week, a green card holder was arrested by ICE agents right at the airport, and the reason behind this arrest is something that's making thousands of legal permanent residents extremely nervous. This person had been living legally in the United States for years, had a green card, was following all the rules, or so they thought. But here's the twist that nobody saw coming. The arrest wasn't for anything recent. It was for something that happened years ago, something that was already dealt with through the court system, something that many people thought was behind them. But in 2026, under the new enforcement priority guidelines, the rules of the game have changed dramatically. And if you're a green card holder, you need to understand exactly what's happening right now. Let me paint you a picture of what actually went down at that airport. This individual arrived at the airport for what they thought would be a routine trip. They've been through airport security dozens of times before without any issues. They had their green card, their identification, everything was in order. But this time, as they were going through the standard procedures, ICE agents were waiting. They were pulled aside, detained, and before they knew what was happening, they were being processed for removal proceedings. The shock on their face, the confusion, the fear, it's something that witnesses described as absolutely heartbreaking. And here's what makes this even more concerning. This wasn't an isolated incident. We're hearing reports from immigration attorneys across the country about similar cases happening at airports, at routine check-ins with immigration officials, and even during traffic stops. So what exactly is going on here? To understand this, we need to talk about something called crimes involving moral turpitude and aggravated felonies. Now, I know these legal terms sound complicated, but stay with me because this affects potentially millions of green card holders. For decades, there were certain crimes that could make you deportable, but there was also a lot of gray area. Immigration judges had discretion. There were waivers available. There were ways to fight your case. But the new enforcement priority guidelines of 2026 have fundamentally changed how old convictions are being treated. The Department of Homeland Security has moved away from discretionary enforcement and is now operating under what they call a zero-tolerance policy. This guidance has essentially expanded the categories of crimes that are now considered deportable offenses, and they're going back, way back, into people's criminal histories. Here's what's particularly alarming. We're not just talking about serious violent crimes here. Yes, those have always been grounds for deportation, and that makes sense to most people. But what we're seeing now is that crimes that happened 10, 15, even 20 years ago, crimes that might have been misdemeanors or minor offenses at the time, are now being reclassified under these new interpretations. Things like shoplifting from years ago, a DUI that happened in your 20s, even some fraud-related offenses that resulted in minimal jail time, these are suddenly back on the table. And immigration officials are actively searching databases, cross-referencing criminal records with immigration status, and targeting people who they believe fall under these new guidelines. What makes this even more sophisticated is that in 2026, the government is using AI-driven scanning systems and advanced biometric data tracking to quickly pull up records that would have been nearly impossible to find manually just a few years ago. The technology has made it effortless for them to dig into your past. Let's talk about what crimes involving moral turpitude actually means, because this is where things get really tricky. The legal definition of moral turpitude is incredibly vague. It generally refers to conduct that is considered contrary to community standards of justice, honesty, or good morals. But here's the problem. That definition is so broad that it can include a massive range of offenses. Traditionally, things like fraud, theft, and certain assaults were considered crimes involving moral turpitude. But under the new 2026 interpretations, immigration officials are casting a much wider net. They're looking at the underlying facts of cases, not just the conviction itself. So even if you pleaded down to a lesser charge, even if you completed your sentence and paid your debt to society years ago, ICE can now go back and say that the original conduct involved moral turpitude, regardless of what you were actually convicted of. Aggravated felonies are another category that's causing massive problems. Now, despite the name, aggravated felonies in immigration law don't always match up with what you'd think of as an aggravated felony in criminal law. The immigration definition is much broader. It includes things like theft offenses where the sentence was a year or more, even if that sentence was suspended. It includes drug trafficking, which can sometimes mean something as simple as selling a small amount of marijuana to a friend. It includes fraud offenses where the loss to the victim was more than $10,000. And here's the kicker. These definitions have been on the books for a while, but the enforcement has been dramatically ramped up in 2026. Immigration officers who previously might have used discretion are now being directed to pursue removal proceedings aggressively for anyone who falls into these categories. And this is where retroactivity becomes critically important. Under current immigration law, even if your offense was not considered an aggravated felony when you committed it, the government can now apply today's interpretation to that old case. So something that wouldn't have made you deportable in 2005 can suddenly make you deportable in 2026, even though you already served your sentence and moved on with your life years ago. This retroactive application might seem unfair, and many legal experts argue that it is, but the courts have consistently upheld the government's right to do this. What makes the situation at airports particularly concerning is that airports have always been a vulnerable point for immigrants. When you're entering or leaving the United States, you're subject to additional scrutiny. Customs and Border Protection has broad authority to question you, search your belongings, and check your immigration status. And now, with these new policies in place, they're coordinating closely with ICE to flag anyone with any criminal history that might make them removable. The databases are all connected. The moment your passport or green card is scanned, the system pulls up your entire criminal history, even arrests that didn't lead to convictions, even expunged records in some cases. And if there's anything that raises a red flag under these new guidelines, you can be detained on the spot. Now, here's something absolutely critical that you need to know if you're ever detained at an airport. Immigration officers may try to get you to sign a form called Form I-407, which is the Abandonment of Lawful Permanent Resident Status form. Listen to me very carefully. Do not sign this form under any circumstances without speaking to an immigration attorney first. I repeat, do not sign Form I-407. When you sign this form, you are voluntarily giving up your green card. You are surrendering your lawful permanent resident status. Once you sign it, it becomes almost impossible to fight your case because you've essentially told the government that you're willingly abandoning your status. Officers may pressure you. They may tell you it will make things easier. They may tell you that you have no choice, but you do have a choice. You have the right to refuse to sign any documents until you speak with an attorney. This is one of the most important pieces of advice I can give you. That signature on Form I-407 can end your life in America instantly, so never, ever sign it without proper legal counsel. Here's something that a lot of green card holders don't realize. Having a green card does not give you the same protections as being a U.S. citizen. A green card is permission to live permanently in the United States, but it's a conditional status. It can be taken away if you violate certain terms. And one of those terms has always been that you can't commit certain crimes. But what's changed is how broadly those crimes are now being defined and how aggressively they're being enforced. In the past, there was often a path to relief. You could apply for a waiver. You could show rehabilitation. You could demonstrate family ties and hardship. Immigration judges had the ability to look at the totality of your circumstances and make a decision based on fairness and justice. But many of those discretionary options have been eliminated or severely restricted under the current zero-tolerance enforcement priorities. Let me give you some real-world examples of the types of cases we're seeing. There was a case just last month where a green card holder who had been in the United States for 30 years was detained because of a shoplifting conviction from 1998. That's almost 30 years ago. The person had raised a family here, owned a business, paid taxes, been a productive member of society for decades, but none of that mattered. The shoplifting offense was classified as a crime involving moral turpitude, and under the new enforcement priorities, that was enough to initiate removal proceedings. In another case, a green card holder with a 20-year-old DUI conviction was stopped at the airport returning from a family vacation. That DUI, which had been fully adjudicated, fines paid, license reinstated, was now being used as grounds for deportation because it was classified as an aggravated felony based on the specifics of the sentence. These aren't hypothetical scenarios. These are real people whose lives are being turned upside down. And what's particularly cruel about this is that many of these individuals had no warning. They weren't told that policies were changing. They weren't given an opportunity to seek legal advice or prepare. They just showed up at the airport one day and found themselves in detention facing deportation. And once you're in removal proceedings, the burden is on you to prove why you should be allowed to stay. It's not on the government to prove why you should be removed. You have to fight your case, often from detention, often without the resources to hire a good attorney, and often under new legal standards that make it almost impossible to win. But here's something important. Even if you're placed in removal proceedings, you still have constitutional rights. You have the right to appear before an immigration judge and present your case. You have the right to legal representation, although the government won't provide one for you. You have the right to challenge the evidence against you. Do not give up these rights. Do not let anyone tell you that deportation is automatic or that fighting is pointless. You have legal avenues available, and an experienced immigration attorney can help you navigate them. Now, you might be wondering, is this even legal? Can the government really go back decades into someone's past and use old convictions as grounds for deportation? The unfortunate answer is yes, in most cases they can. There's a legal principle called retroactivity, and when it comes to immigration law, the courts have generally held that immigration consequences can be applied retroactively. What that means is that even if your crime didn't make you deportable at the time you committed it, if the laws change later or if the interpretation of existing laws changes to make that crime deportable, you can still be removed. It seems unfair, and many legal scholars and immigrant rights advocates argue that it is unfair, but multiple court decisions have upheld this principle. The government's position is that immigration status is a privilege, not a right, and that privilege can be revoked based on current interpretations of the law, regardless of when the underlying conduct occurred. There's also the issue of how these cases are being prioritized. Under previous administrations, there was at least some effort to focus enforcement on individuals who posed a genuine threat to public safety. The idea was that resources were limited, so they should be directed toward people who had committed serious recent crimes. But the 2026 zero-tolerance policy has essentially eliminated those priorities. Now, anyone with any conviction that could potentially be classified as a deportable offense is fair game. Immigration attorneys are reporting that their clients are being picked up for offenses that are minor, old, or both, and the pace of enforcement has increased dramatically. ICE is clearly operating under a mandate to increase deportations, and they're meeting that mandate by going after the low-hanging fruit, which unfortunately includes a lot of green card holders with old minor convictions. So what can you do if you're a green card holder with any kind of criminal history? First, and most importantly, you need to talk to an immigration attorney right away. Not a notario, not a general practice lawyer, but an attorney who specializes in immigration law and specifically in removal defense. You need someone who understands these new policies and can evaluate your specific situation. They can look at your criminal record, determine whether you're at risk, and advise you on potential options. In some cases, there may still be forms of relief available. There are waivers for certain types of offenses. There are cancellation of removal applications for people who meet specific requirements. There are asylum claims in certain situations. But you need expert legal guidance to navigate these options. Second, if you have any upcoming travel plans, you need to think very carefully about whether to go through with them. As we've seen, airports are a major point of vulnerability right now. If you have any criminal history whatsoever, traveling internationally could result in detention when you return. I'm not saying don't travel, but I am saying that you need to consult with an attorney first and understand the risks. If you do decide to travel, make sure you have contact information for an immigration lawyer readily available. Have a plan for what your family should do if you're detained. Make sure someone has power of attorney to handle your affairs. These might seem like extreme precautions, but given what we're seeing happen, they're entirely warranted. Third, if you have old convictions, explore whether there are any post-conviction relief options available. In some states, you may be able to get old convictions expunged, sealed, or vacated. Now, this doesn't always help with immigration consequences because federal immigration law doesn't always recognize state expungements, but in some cases, it can make a difference. An immigration attorney working with a criminal defense attorney can evaluate whether this is an option for you. The key is to be proactive. Don't wait until you're in removal proceedings to start thinking about these issues. Now, let me address something that's very important for those of you who are green card holders but haven't yet applied for naturalization to become U.S. citizens. If you have any kind of criminal record, even something minor from years ago, you need to be extremely careful about applying for citizenship right now. When you file Form N-400 for naturalization, you're essentially inviting the government to take a very close look at your entire history. They will review every aspect of your criminal record. If they discover something that makes you removable, your citizenship application could trigger removal proceedings instead. This doesn't mean you should never apply for citizenship, because ultimately, citizenship is the best protection you can have. But it does mean that you absolutely must consult with an experienced immigration attorney before filing that application. Have them review your criminal history first. Let them assess whether there are any issues that need to be addressed before you apply. The wrong move at the wrong time could cost you everything. For those of you who have family members who are green card holders with any criminal history, you need to have conversations with them now. Make sure they understand what's happening. Encourage them to seek legal advice. Help them prepare for the possibility that they could be detained. Talk about financial plans, custody arrangements for children, everything that would need to be addressed if the worst happens. These are difficult conversations, but they're necessary in the current environment. It's also worth understanding that this isn't just affecting individuals. This is tearing families apart. Many of the people being targeted have U.S. citizen children, U.S. citizen spouses, elderly parents who depend on them. When a green card holder is deported, the ripple effects are devastating. Children are left without parents. Families lose their primary breadwinner. Elderly parents lose their caregivers. And all of this is happening because of conduct that in many cases happened decades ago and was already punished through the criminal justice system. The human cost of these policies is immeasurable. Looking ahead, it's unclear whether these policies will continue, be expanded, or eventually be rolled back. What we do know is that right now, in 2026, this is the reality that green card holders are facing. The enforcement is real, it's happening every day, and it's not slowing down. Immigration courts are backlogged with cases, detention centers are filling up, and thousands of families are living in fear, wondering if they're going to be next. If there's one message I want you to take away from this video, it's this. If you're a green card holder, do not assume that you're safe just because you haven't had any recent problems. Do not assume that old convictions are in the past and forgotten. Under current policies, they are very much in play, and they can be used against you at any time. Do not sign Form I-407 under any circumstances without legal counsel. Remember that you have rights even in removal proceedings, and an immigration judge must hear your case before you can be deported. Get informed, get legal help, and take steps to protect yourself and your family. This is not the time to bury your head in the sand and hope for the best. This is the time to be proactive and prepared. Thank you for watching Breaking U.S. Immigration News. If this video has been helpful or informative, please share it with anyone who might need this information. Stay informed, stay safe, and I'll see you in the next video.